Mr. Simpson is again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Blazer, Ms. Snyder-Chapman, Mr. Scheck, people represented by Ms. Lewis, Mr. Darden, Mr. Hodgman. Also present is Mr. Hayden, who represents a subpoenaed witness, a Mr. Purdy. We have on calendar today a Brady motion at the request of the defense. Court's understanding the Brady motions comprise two issues. One, the disclosure of photograph contact sheets, and secondly, information regarding conduct by Detective Furman while at the West Los Angeles Division sometime in 1987. All right, Mr. Scheck.
What we propose to do is first is call the following witnesses: Assistant District Attorney Lucian Coleman, then police officer named Aronson, and then Detective Purdy.
All right, what's your offer of proof beyond the declaration of Ms. Coleman?
Well, we had a proceeding in chambers where I laid out much of it, but I think it's contained essentially in the declaration of Lucian Coleman, and we need to make this offer in order to, first of all, put on the record for the court's benefit what we believe in the course of the investigation of the allegations raised by Ms. Coleman was misconduct by the prosecutors insofar as they failed to pursue adequately the allegations herein, or, if it were not by the prosecutors, a failure to pursue it by internal affairs. The problem that we have is that the information contained in the Coleman affidavit and the information that we have obtained in the discussions with these officers, which, as the court knows, have conflicts with the Coleman affidavit.
Well, Mr. Scheck, let me ask you this.
Yeah.
Ms. Coleman's affidavit, Ms. Coleman's an officer of this court,
Yes.
has appeared before this court. I'm well acquainted with her. Her affidavit essentially says certain things were said to me. I passed that information and my concerns based upon that information on to the prosecution team here.
Yes.
I cooperated and was interviewed by the law enforcement agency that's involved here. She has no direct knowledge of any evidence that relates to the issues in this case. What she merely does is raise certain issues at certain points in time. So why is it necessary to call her as a witness at this point?
Well, actually, we made an offer with respect to that this morning to the prosecutors, basically saying that we would, if they would stipulate that Deputy District Coleman's statements with respect to her interactions with these prosecutors was accurate, and then she would simply sign the declaration with respect to the what we all know as a conflict of testimony between her and the police officers, that we would just put on the police officers. That would have been fine by us. Mr. Hodgman declined to do that. There is another issue as well that arose yesterday in the conversations we had on tape with Detective Purdy that is not contained in the Coleman affidavit, but is something that she would testify to, and that has to do with this very critical incident involving Detective Purdy and Mark Furman, where Detective Purdy told Ms. Coleman that he had been involved in a case with Mr. Furman, that Furman had done the police report, that Purdy had testified at a preliminary hearing. Subsequently, it arose that there was a conflict between the...
I think Mr. Scheck is talking about a matter that relates to confidential personnel files. There is a statutory procedure pursuant to 832.5, 832.7, 832.8 of the Penal Code, as well as Evidence Code Section 1043, 44, 45, 46, and 47. The defense has made no attempt, even though they had Ms. Coleman's, the information from Ms. Coleman's declaration as far back as April, possibly even as early as February. Defense has not made a motion pursuant to those statutes, and they should not be allowed to discuss those matters in open court until such time as they do so.
Your Honor, if I may just complete, you asked me why we needed Ms. Coleman to testify.
All right, I'm aware of that situation.
Well, no, my point is, this is what Ms. Coleman would testify.
I understand.
And counsel has, when we tried to ask Detective Purdy about these matters yesterday, his counsel raised this privilege issue and they refused to discuss it. And we have to make a record here with respect to what Purdy told Coleman, and then it becomes a matter for the court to pursue, and we have our legal remedies under the Constitution of the United States.
All right, let me ask you this. Why was that not reduced to an affidavit from Ms. Coleman? I'm just trying to avoid...
I understand that. I would like to avoid that as well, Your Honor, but we did not put these incidents together as clearly until we had a conversation yesterday with Detective Purdy and were able to try to link the one incident where we believe that this probably, and we don't know because Detective Purdy wouldn't answer the questions, but it is probably the one instance where he was partnered with Mark Furman. And the import of that is that there is substantial conflicts between Ms. Coleman and Detective Purdy about what Detective Purdy said to her and what might have been in the diary of Detective Purdy with respect to the actions of Detective Furman, a diary that he concedes he burned when he knew that it was going to be sought by either the prosecutors or internal affairs, which we consider a potential obstruction of justice. Now, that reflects upon the credibility of Detective Purdy. We have to elicit from Ms. Coleman the testimony about that incident that's not contained in the affidavit, because now we see what we don't have and what we want the court to seek from internal affairs.
So let's assume the best possible scenario for the defense. Detective Purdy comes in and says, I worked with Detective Furman back in 1987 at the West Los Angeles Division. The guy was a jerk. I didn't like him, didn't get along with him. He harassed me. I felt, and apparently Purdy makes a statement to Coleman, that I would not put it past Furman to plant evidence. I suspect Furman as being one of the persons involved in putting swastikas on my locker. I suspect him, but I don't know. All right, is that the essence of what we're talking about here?
No.
What else?
Detective Purdy has admitted he had a diary which he kept with respect to incidents that were occurring to him in the West LA Division. I think it's clear from the way he answered the questions yesterday on tape in the presence of the district attorneys that he was afraid of Detective Furman and other officers in what is known as a SPU unit, a special problems unit, that he thought that he was being ostracized because they thought he was a plant from Internal Affairs Division. He told us yesterday he never heard Detective Furman or ever heard about Detective Furman uttering anything sexist, anything racist, or engaging in any misconduct. That's his position. He says in this diary there is records about the, as he recalls, the swastika incident, the incident involving the surveillance that he did, the case he did with Detective Furman that he won't answer any questions about, where there was a conflict of testimony between Purdy and Furman, and then Purdy went along and conformed his testimony with the police report filled out by Furman, got into trouble and got suspended for 15 days because his subsequent testimony was different than his preliminary hearing testimony. Our position, Your Honor, is we think you should see those records. This was never brought to the court's attention to the best of our knowledge because we didn't receive anything from the court in terms of the redaction and the destruction of these logs. We think Detective Purdy, despite his hatred of Mark Furman, is willing, as indicated in the Coleman affidavit, not to testify against Furman. That's what the Coleman affidavit talks about. That Purdy said to her, I will not testify against the prosecution in these matters. I will not testify about Furman. I'm going to burn my diary. And indeed, he burned his diary. And told us yesterday he burned it without even looking at it.
Let's assume that then the logical thing to do, there are two logical things to do. One, file a petition motion for Mr. Purdy's file, because if he got 15 days off, that ought to be reflected in his personnel file. Secondly, you should ask for an order from this court, directing the district attorney's office to go through the vaunted promise system, do a witness search in 1987 for a case where Purdy and Furman show up as witnesses in the same case, and see if you can find the same information that way.
Most
All right,
respectfully...
so this is a discovery issue at this point.
Well, most respectfully, this is a Brady motion. Our legal position is that our right to confrontation and due process under the United States Constitution overrides any statutory privilege about personnel files. There was an investigation with respect to this case by Internal Affairs that presumably this court reviewed. In the redacted versions that we received from this court, there is nothing in it about a destruction of logs. There is nothing in it about this situation where Purdy was in conflict with Furman and conformed his testimony. We don't know why that's true. We don't know whether Internal Affairs followed this up. We don't know if there's anything about destruction of logs, which we think is a plain obstruction of justice.
Counsel,
We
destruction
don't know.
of a personal diary.
Oh,
It's
no.
not a log.
Oh, well, wait a second. Detective Purdy indicated last night that Ms. Coleman did refer to it as a log. He's calling it a diary. But it's very plain from what he told us yesterday that he was keeping a diary of incidents involving Furman and these other officers because he had good reason to be concerned about them. He immediately requested a transfer after the swastika incident and was sent out of that unit, but as he indicated yesterday, there was no follow-up. There was no interviews with officers as to who did it and who might have done it and who had access to that locker.
All
What
right,
we're
Mr. Scheck,
saying, Your
hold
Honor...
on, Mr. Scheck, let me ask you this.
Yeah,
What you want is access to Purdy's file.
yes.
You probably want the district attorney's file so you can also try to backtrack that same case. Assuming you can find that file, then you can get the court file, which should have transcripts of all of these things and the differences in testimony, correct?
Yes.
All right. What else do you want?
Well, we also want, as part of this, unless the court is willing just simply to accept as true this declaration, which we would hope that the prosecutors would stipulate to with respect to what they were told and when they knew it. We think that there's a serious issue here with respect to prosecutorial misconduct and charges to the jury with respect to what prosecutors knew about Mark Furman and when they knew it. We also think that, and this is something that I want to add as a grounds for relief, in looking over the pretrial, this all relates, Your Honor, to the pretrial discovery efforts or the discovery efforts during the course of the trial by the defense to find out about Detective Furman and his racist comments, his willingness to manufacture evidence and break rules, and also about his credibility and character. In looking back at another one of the motions filed, we sought the psychiatric records of Detective Furman from the police department and the Marine Corps. I commend the court's attention to the affidavit filed by Detective Furman in support of the privacy motion made by Turtello, who was representing him at that time. I would submit to the court there was a perjured affidavit. In that affidavit, Detective Furman indicates that his statements to the psychiatrist with respect to his genocidal statements and his statements in derogation of African Americans and others were not, quote, intended, were not statements that were in derogation of any ethnic group. What he said was these were just descriptions in a therapeutic context to my psychiatrist, to the psychiatrist. And it's my understanding that the court didn't seek those files. We want those files as well, or we want certainly the court to review those files, because we think there's potentially exculpatory and extrinsic evidence with respect to Mr. Furman's mental state. It's going to be argued to this jury, as is evident by Ms. Lewis's argument yesterday, that anything that Detective Furman said in these tapes to Ms. McKinney and many other statements that he made were all, braggadocio, and they're all boasts and things about him, and that they're going to make the argument that it's not only impossible but irrational for him to have planted evidence or covered things or gone into the Bronco or any things of that nature. He wouldn't have possibly done that because it would be the act of an irrational person. Well, we think that in those psychiatric records as well, there may be exculpatory evidence that would indicate exactly what kind of an individual Mark Furman is and why he might do these things that we might be able to present as extrinsic evidence. And we are very, very concerned as to what Internal Affairs and other investigators knew about Detective Furman and when they knew it. Because from a constitutional point of view, the prosecutors in this case may have taken all these pieces of evidence that they got from various detectives that were then communicated to district attorneys and were given to them. And they may have said, okay, we'll give it to Internal Affairs and we won't pursue it ourselves. That may have been their attitude. But from the constitutional point of view, in the terms of this defendant, they're all law enforcement. And we want to find out about all of it under Brady, under our due process rights. And we are concerned that we didn't get everything, or it doesn't exist, frankly, in the records that this court turned over to us. And of great interest is the credibility of Detective Purdy as to what he really knew about Mark Furman, why the burning of his diary was not pursued, because you can call it a diary, Your Honor, but by every...
Well, was it an official police document?
No, it was a personal document.
All right.
But, Your Honor, it's evidence, because there may be some conflicts in the testimony about what's in that diary or what he said was in that diary, but there is no conflict about the fact that, A, he revealed it to Deputy District Attorney Coleman, B, he destroyed it because he knew that that diary was going to be sought. And that diary contained information at least about the swastika incident and about this other matter that may have involving him and Detective Furman and surveillance and the testimony, etc. And it may, we believe, have contained more. That's what we're pursuing. That's what we want to find out about. And we are very concerned that none of this was pursued before. I simply don't understand how a detective can be telling district attorneys that he destroyed a diary that contained allegations about Mr. Furman in regard to at least the swastika incident and this other surveillance incident, if not more, and he burns it rather than turn it over to him, and that's the end of the inquiry. Where I come from, that's an obstruction of justice. Because notwithstanding the fact that it's a personal diary, it is now evidence. Any personal matters certainly would have been redacted and taken out of it and not put in a public light. But the point is, what he said about those incidents, which he was carefully recording because of these officers in West Los Angeles, whom by his own statement to us yesterday he had good reason to fear, that's of serious interest and could lead to exculpatory information. We didn't know anything about it, and that's what we want to establish at this hearing. In addition, with respect to Detective Aronson, he, again, completely conflicts in his statements with Lucian Coleman, and we think that Lucian Coleman's testimony and the documentation that she has here in court will prove that he's lying too. And that is also a matter of serious concern because it concerns statements that Detective Furman made about Nicole Brown Simpson and her anatomy and private information that he had that should have been pursued in terms of his relationship with the victim in this case and what he knew and when he knew it. And if he was even making these statements in another context, it goes to his state of mind, his psychiatric condition, frankly, and his bias and credibility in this case, and we should have known about it. So that's what we want to pursue at this hearing. We have to make a record in this regard.
All right. Mr. Hodgman?
Thank you, Your Honor.
I'm sorry, I want to hear from Mr. Hodgman first.
Clearly, Your Honor, pitches...
I'm sorry. I want to hear from Mr. Hodgman
I'm
first.
sorry.
Our names are too similar. Excuse me, sir. You don't get to own this. And good morning, Your Honor.
Good morning, Mr. Hodgman.
Your Honor, first of all, for clarity of the record, yesterday we made an inquiry about the court's request of the defense last week to provide reports to the court of what the defense has done in the last 6 months with regard to these various witnesses. And did the court indicate that some reports were received by the court?
No, what was requested were copies of the reports that were turned over to the defense as a result of our discussions back in February of this year. That's what's been turned over to the court.
Okay. So the court has no information about what the defense has done in the last 6 months to pursue the leads which flowed from those reports which the court gave to
Well,
the
the
defense. Is that
information I
correct?
have is contained in Ms. Coleman's affidavit indicating the conversations that she's had with the defense and what information was provided and when. I mean, there is, Ms. Coleman's affidavit does contain that information.
Very well. Your Honor, I think it's important for the court and for us all to identify with some precision what relief the defense is seeking. Now, this morning, the defense raises the notion they apparently want Detective Purdy's personnel files. Detective Purdy is here represented by counsel in that regard because, as the court well knows, there is one exclusive statutory mechanism by which a party, namely the defense, can get to those records, and that is a pitches motion. We considered this once before, about 6 or 7 months ago, and the court directed, or pursuant to the defense motion, brought under pitches. The court reviewed materials, determined what was relevant, what was not, and provided those to the defense. Now, 6 or 7 months later, the defense comes again complaining of their desire to get some type of discovery.
It's more like 5 months.
Call it 5 months. The point being, Your Honor, and as Mr. Haddon has already pointed out to the court, but let me reaffirm, the defense, at least as of April 17th, 1995, and more than likely earlier, has had access to all the people that they wanted to interview. And yet, it is only last night that they speak with Detective Purdy. So at this point in time, they have an interview from Detective Purdy, and the question remains, do they want to call him as a trial witness? If so, well, let's obtain the appropriate discovery, and perhaps we'll run a 402 to see if he has any relevant testimony to offer to this jury. But the proper statutory mechanism for obtaining what they appear to desire, what relief they seek with regard to Officer Purdy, is well defined, it's clear, it's the pitches motion. Now, with regard to the people's obligation to produce material under Brady, it is a principle with which we are well aware and has been discussed many times in this case. And I think it is prudent just to review some of the salient points of chronology which have led up to today's hearing. First of all, as the defense concedes, and as Ms. Coleman states in her as yet unverified declaration, this information about the log, diary, however we wish to characterize it, did not come to the attention of the people until early February of this year. And the court will well recall what happened after that catalytic event, if we wish to characterize it that way, occurred. I came to this court and informed the court and counsel that some information had come to light regarding Detective Furman. Because the information perhaps or possibly involved officer misconduct, the information had been referred for investigation to the Internal Affairs Division of the Los Angeles Police Department. That's a matter of record, and counsel knows it. The court, I'm sure, is reminded of it as we speak. Subsequent to that, the court conducted an in-camera review of that material, whatever it was, that was gathered by the Internal Affairs Division of the Los Angeles Police Department. The court made certain determinations as to relevancy. The court, on March the 8th of this year, directed that certain of those materials, redacted as the courts found appropriate, were given to the defense, as well as to the prosecution. At that point in time, the defense had in its possession certain information which they were free to follow up if they so choose. Now, we can make an assumption at this point in time that as of at least March the 8th or shortly thereafter, the defense was aware of Detective Purdy and other information. And at the very least, we know from Ms. Coleman's own declaration before this court, as of April the 17th of this year, they knew everything with regard to what Ms. Coleman had indicated to the internal affairs officers. So here we are 5 months later. It is only last night that the defense has interviewed Detective Purdy, that they come before this court and say, we want Detective Purdy's personnel records. Well, I think it is appropriate for this court to ask at the very least, where were you for the last 5 months in terms of conducting this investigation? We have an issue of time.
Mr. Hodgman, do you have any difficulty in at least doing a promised computer search to see if you can find this case?
No. If the court would like us to do that, I'll initiate it today.
All right, you're so ordered.
And, you know, the point, well, this is part of my overall theme before the court this morning, Your Honor. We have complied with Brady. Before Detective Furman ever testified, the court had issued its order with regard to the pitches material regarding Detective Furman. We had gone through the proper procedural mechanism so that, in fairness to all parties, including the defendant, the people, and the officers involved, this material could be reviewed as it was by this court, and determinations could be made as to relevancy. That has been done. As far as the remaining relief sought by the defense, the people are well aware of their Brady obligations. We have an ethical duty to turn over information that might tend to be exculpatory to the defense. We have done that. If we come into possession of other information, we will turn that over. It is the people's position. There is no need for further hearing on this. There is no need for live testimony. The defense has interviewed quite a few people now. I've made arrangements to facilitate an interview with one remaining deputy district attorney, with Mr. Shapiro. That deputy district attorney, for personal reasons, is unable to come to this court.
Well, on that point then, let's assume that Ms. Coleman's willing to sign the declaration that's before the court. Do you have any desire to cross-examine Ms. Coleman with regards to those issues?
Perhaps not. The point is, with regard to the declaration, in fact, let me clear something up. It was posed to be by Mr. Scheck this morning that we stipulate that all that information is accurate. Okay. Well, Mr. Scheck is cutting out a sub-part of the declaration, and that is indeed accurate. All I can say is, and perhaps we would be willing to stipulate, is that this is what Ms. Coleman would say if she were called to testify. Whether or not we would cross-examine her, we'll reserve that right depending on how this court decides to proceed with this.
Here's how we can do this. Ms. Coleman signs the declaration. You have the right to object to the filing of a declaration and demand your right to cross-examine. If you have no desire to cross-examine Ms. Coleman as to the contents of her declaration, then we can just have her execute the declaration and be on her way, since I'm sure she's got other things to do today. And then we can litigate this matter further.
Well, my point to the court is, it is unnecessary to delay this trial and create the specter of yet another mini-trial, which prevents this jury from receiving further evidence for some period of time, because we are prepared, as far as the people are concerned, to do as the court directs and what our own ethical obligations tell us to do. We have complied, and as the court has asked us to check promise, to see if there's a crossover between Purdy and Furman, we'll do that today. We're happy to do that. As far as delving into officers' personnel files, as Mr. Haddon correctly points out, there's a statutory mechanism for that. And if the defense wants to file a motion and take a 2-week delay, in order to have that heard, or bring an order shortening time so that it may be heard more expeditiously. That is their prerogative. The people will not stand in their way. They can file whatever motion they want. The point is, after all of that, there is no need for testimony. Let's get on with the trial, Your Honor.
All right, so I take it the bottom line then is that you're willing to waive your right to cross-examine Ms. Coleman.
Well, we will reserve that right for now. As yet, Ms. Coleman hasn't filed or hasn't signed the declaration. I believe she will. If the court wants to have a protracted proceeding where we call police officer witnesses...
Counsel, I'm trying to avoid that by asking you...
As am I. And I'm saying for now, if it will get this case to the jury quicker, we will waive that right. However, if we will reserve it only in the sense if the court is going to allow further testimony from other officers for whatever purpose in connection with this hearing, then we may very well
You may wish to call her as a witness yourself. I
That's
understand
correct.
that.
But for the moment, to move these proceedings along, we'll waive that right conditionally.
Thank you.
Now, with that, again, I don't know what further relief the defense is seeking. They've got pitches available to them. The people have done their part. We did it 7 months ago.
Mm-hmm.
So I think we have to hear from the defense what else is it they want. I will initiate the promise search today, and I will provide that to the defense.
All right. Mr. Head.
Thank you, Your Honor. As Mr. Hodgman said, and as I said earlier, pitches clearly hold sway here in regards to the personnel issues. I would just like to add, or to clarify rather, that make some comments regarding what Mr. Scheck brought up. Just because Mr. Scheck wants to fantasize that there is evidence in the diary doesn't mean that there is any. As my client told the defense and the prosecutors yesterday, the diary was kept as a personal matter, that predominantly it contained references to romantic events between himself and his wife, which is why it was an intensely personal matter, that he keep it and destroy it. He was not interested in having his personal life exposed to the public. In addition, the incidents that he related about Mark, that he had in the diary about Mark Furman, he's already given those to the defense as well. Ms. Coleman's declaration doesn't really say anything to the contrary. Conspicuous by its absence in that declaration is any discussion of actual incidents of misconduct with Mark Furman. She mentions only that he cited some incidents with Furman that were maintained in the diary and nothing more. There is nothing in there, referring to her declaration, nothing in there that references any misconduct by Furman in relation to the pertinent issues that have been raised by the defense in terms of planning of evidence, racism, sexism, etc. And what I think the defense is asking the court to do is to engage in multiple mini-trials possibly here, and to ask the jury, if this were to ever get in front of the jury, just to wildly speculate as to what might have been in the diary when there's absolutely no evidence that there was any references to misconduct in that diary. Thank you.
Mr. Scheck.
Thank you, Your Honor. I think that there's some confusion here. This is a Brady motion. And let me make very clear that we have newly discovered evidence that has come to light in the Furman tapes that puts this in an entirely different posture and has led us to more vigorously pursue what is in these logs, what is in the matters that were referred to you in camera from the Internal Affairs Department and what was pursued in these investigations. We now know a lot more about Detective Mark Furman, his view of policing, the way he proceeded, and most particularly, we know a lot more about his activities in 1985, 86, 87, most particularly 87, when he was dealing with Detective Purdy and others in West Los Angeles. We know a lot more now, and that is what guides our renewed investigation of this. Secondly, and this goes to the case of United States versus Bagley, which is a Supreme Court precedent that is the touchstone for all of this. We made specific requests for these records and what the prosecution knew in terms of exculpatory material about Mark Furman, about his misconduct, about his racist attitudes, about his willingness to falsify testimony and manufacture evidence, and his psychiatric records. We were pursuing all of that with specific requests. We then received back from the court redacted copies of what had been pursued as an investigation, we take it, by Internal Affairs of the specific incidents involving the swastika, involving the remarks of Detective Aronson in this case. I want to make it very clear that as one element of relief here, we are seeking further discovery of those records. As the Bagley case makes clear, when the defense makes a specific response for exculpatory material and then gets an answer from the prosecution which is incomplete and misleading, that is a problem in terms of the ultimate exculpatory evidence that is discovered. And in fact, we are supposed to be given an assumption that we would have found more if we pursued this without having been misled. In other words, the redaction that we got from the court contains nothing with respect to the destruction of a diary or log that contained entries with respect to Mark Furman about the swastika incident, and now we know other incidents of relevance in terms of possible perjured testimony by Purdy and or Furman, or falsifying of police reports by Furman. Now, we didn't know about that because when we received this redaction, there's nothing in there about logs. Now, we don't know whether Internal Affairs, in questioning Deputy District Attorney Coleman, went into the log incident, although we know from her that they did. So we don't know whether the court ever saw anything about that, or if you saw anything about that, fully appreciated its significance. But now, having talked to Detective Purdy, after having heard the Furman tapes, after pursuing this, we know it is significant, and we can now particularize exactly what its significance might be in terms of Furman filling out false police reports, in terms of cover-ups here. Now, our grounds are based on the Due Process Clause in the Sixth Amendment of the Constitution. We are basing it on Davis versus Alaska and a whole line of cases that follow that say statutory privileges with respect to personnel files, whether it be the Internal Affairs investigation here that we've already pursued by way of a Pitchess motion, and we want more of that, we want to see all of that, or personnel files with respect to Mr. Haddon's client about this incident. All those statutory privileges give way to our constitutional right at this late point in the trial to get to the bottom of this. That's what we're saying. That's what we want this court to rule on. That's the record we want to make. Because we feel that this information has been hidden. And in light of the Furman tapes, and in light of this man taking the Fifth Amendment on substantial issues with respect to moving evidence and manufacturing evidence in this case, we want to find out more about it. And it also goes to the court's previous rulings with respect to his psychiatric records. We contend as well, Your Honor, that in terms of the prosecutor's Brady obligations, they can't hide behind the fact that they just dumped all of this to Internal Affairs and now say, well, it's all privileged, you can't see it. We don't think that's adequate. They had an option. They didn't have to send all this information to Internal Affairs to have them pursue it and then try to hide behind some kind of privilege with respect to these records. They could have, should have pursued it themselves. This was information that was being given to them by their own deputy district attorneys. They were informed, be it in February. Fine, it's in February, at about the time that Mr. Hodgman came forward and mentioned that there was this swastika incident that was being pursued by Internal Affairs. He never told us, I'm sure he'll concede, that there were logs that were, diary that was destroyed destroyed because it was being sought, because the officer knew the district attorney's office was going to ask for the diary. He then destroyed it. Now, frankly, with all respect to Mr. Haddon, he's representing his client admirably. I am not fantasizing that Detective Purdy destroyed this diary. He told us that last night. He told us he destroyed the diary after he knew that Lucian Coleman had brought this matter to the attention of Mr. Hodgman, and Mr. Hodgman was going to pursue it. And rather than have that diary examined, and it does contain entries about Detective Furman, he burned it. And it is not an adequate answer to say that it contained personal information. Of course it might have. And as a police officer, I'm sure he should have recognized, as a law enforcement official, that the privacy rights with respect to that information would certainly be protected, because that's not at issue. What was at issue was what he had to say about Mark Furman and about incidents that were of significance. I should also add in passing, and it's not clear from the affidavits, so the court should just know it, I don't think we mentioned it in chambers, that Ms. Coleman indicates in her declaration that she learned from someone, she's not sure who, that there had been reports that Detective Furman had, on weekends, had walked around in Nazi uniform at his home.
Isn't that really just another example of all the rumor mongering that goes on
Well, no,
about all the people in this case?
Your Honor, it is rumor mongering. I just want to, and Detective Purdy told us yesterday that he was the source of it.
Attorney's office are well known for.
But I think that what the court should appreciate is that we have an incident here where Detective Furman is alleged to have put a swastika on the locker. But just hear me out for a second. My understanding of Nazis is that they don't like Jews, they don't like blacks, they take law into their own hands, and they engage, and they have exactly the kind of attitudes that we heard in the Furman tapes. I think it's a fair statement that what we heard in those tapes were the rantings, and well, they weren't even rantings, were the calm discussion, the chillingly calm discussions of somebody that held Nazi attitudes, yes. Now, if he is the one that put a swastika or was with a group of police officers, which is even worse, that put a swastika on Detective Purdy's locker, and he held attitudes like that, yes, that's Brady material. Yes, that's an indication that he could hold racist attitudes. Yes, that's an indication that he's the kind of officer that would break the rules and manufacture evidence and do almost anything to get a guilty person he thought was guilty, a bad guy. The comments that he made about the posses. You know, when you look at those tapes, you know that's exactly what Mark Furman might do, because that's what he's talking about at length in those tapes in his own voice.
What's missing?
So I think that that was
potential.
potential.
In that scenario, Mr. Schick?
I'm sorry?
What's missing in that scenario?
Which scenario?
Your Nazi scenario. Purdy says, I suspect Furman was the person who did it. I don't know. So I'm supposed to allow evidence that I think it was this guy from this incident in 1987?
No.
Okay.
What's
Just
in
so
the
we're clear.
diary? No. My point here is that this
I mean,
whole...
we can have expert opinion as to guilt or innocence of defendants as
No.
well.
Our claim here and our concern is what investigation was done and what additional evidence might be out there. We are saying that people did not pursue this. If we are given an opportunity to pursue this with all the facts, we might find evidence that they should have found, but did not
But haven't you had the
pursue.
opportunity since March?
No. What I'm saying very clearly to the court is that because the redaction that we got misled us with respect to the existence of logs and the destruction of logs, and from fully learning about the relationship between Purdy and Furman and this potential incident where Purdy was put in a position where he perjured himself for Furman because Furman falsified a police report, if that is indeed the chain of events, we were misled because there's nothing in these redactions that allows us to figure that out and pursue it, so we didn't know it. Number two, we now have the Furman tapes, which puts us in a much, it's newly discovered evidence that puts us in a firm position to go forward and see exactly what Mr. Furman's MO was and exactly what his relationship was with Detective Purdy and others in West Los Angeles. Now, it's far clearer to us and much more significant. If we had had all that information earlier, we could have pursued it earlier, but we were misled because an inadequate investigation was done. Frankly, from what they're saying, no investigation was done about this by the district attorney's office. Basically, their attitude was either A, get out of my office, I don't want to hear it, or B, here's some things that sound bad, let's just give it to Internal Affairs to investigate. We don't know anything more about it. The defense certainly doesn't know anything more about it. Then we get redactions
All right, Mr.
which
Scheck,
mislead
do you have
us.
anything new to add?
No.
Thank you. Do you want to have Ms. Coleman execute the declaration?
Can we just have the declaration augmented with respect to the conversations we had with Detective Purdy about this incident with Mr. Furman?
I think that's part of our discussion already.
All right, as long as the court's aware that she would affirm that as well.
She also has with her what the court asked. She has additional information regarding times and meetings with Detective Aronson, which are very important, and we'd like those included also in the declaration.
All right, if you'll provide that to the court.
Thank you.
As it appears the defense wants to amend or modify or supplement Ms. Coleman's log, we would appreciate getting a copy of that as well, and we advise the court that depending on what is introduced by way of the supplemented declaration, we may very well be filing declarations as well.
All right.
These are just additional official documents of the district attorney's office.
All right, thank you, Ms. Coleman, you're excused. All right, issue here is as to the Purdy Aronson issues, that of Brady and the prosecution's obligation to make information that is potentially exculpatory or that is exculpatory available to the defense for analysis. On the basis of the declaration by Ms. Coleman, it appears to the court that there were some legitimate concerns raised with regards to Detective Furman at that time, and that it was the appropriate course of action for the district attorney's office to approach the court to advise the court of that information under our discovery statutes, and then to relay to the court that same information after the internal affairs investigation had been conducted. This court, on the basis of the internal affairs investigation, ordered the disclosure of the statements to internal affairs made by, amongst others, Lucien Coleman, and that disclosure was ordered on March the 8th of this year. I find that the disclosure by the district attorney's office to the court was done in a timely manner and in accordance with their Brady obligations. Secondly, the information that was given to the defense at that time was sufficient to allow them to make inquiry into all of the issues that have been raised so far this morning. Specifically, the court refers to paragraph 17 of Ms. Coleman's affidavit, which indicates that the above information that is contained in this affidavit was all at that time available to the defense as of April the 17th, 1995. that the information regarding Purdy, regarding any diary that he might have kept, any of that information, all of that information was then available to the defense. So I find no Brady violation with regards to the conduct of the District Attorney's Office in this matter. I'm going to order the District Attorney's Office to conduct a promise search cross-referencing Furman and Purdy, and to deliver that information forthwith to the court. That's a computer search that should be able to be accomplished within 1 hour. As to the desire for the court to order the production of Officer Purdy's personnel file, the obligations under Brady are consistent with the Pitch's discovery scheme. As such, it is a discovery device, and if there is Brady material, it will be disclosed. However, this court must abide by the legislature's determination that this is the process and procedure. This information regarding Purdy and this information regarding Purdy from Ms. Coleman was available for what appears to be the last almost 5 months. So the court will not take any further action pending the filing of an appropriate Pitch's motion as to Detective Purdy. Court will entertain a motion to shorten time. All right. Any other Brady issues we need to discuss?
Here's the matter of the contact sheets.
I'm sorry?
Contact sheets.
All right.
And has the court been able to review the request for sanctions
Yes.
letter that was submitted?
Yes.
We believe, Your Honor, that the testimony yesterday of this week of Mr. Rokar is extremely significant. It's significant because it establishes that the picture of Detective Furman pointing at the glove occurred at night, not at 7 in the morning, over about an hour and a half after daybreak. More significantly, it puts Detective Furman in an area by the evidence, at a time when he is unsupervised, or unobserved, I should say, by others. And it is in complete contradiction not only with his testimony, but an apparent contradiction with the testimony of other officers. The pictures speak for themselves and are extremely powerful evidence. Now, the problem that we've had in this case, as the court is well aware, is that we have been requesting a photo log or a listing of the order and/or time that pictures were taken, or B, an opportunity, or contact sheets, or C, an opportunity to make contact sheets from the negatives. This was pursued in discovery at pretrial, and it was pursued during the trial. Now, Ms. Clark got up here yesterday and said that she was able to look at the photographs and see numbers on the face of the photograph, and she herself had put together a stack of the photographs in order so that she knew the sequence. Well, that is something that Dr. Lee, Dr. Wolf, Dr. Batten, myself, the other lawyers on this team could not do for a number of reasons. Number one, there are different photographers in this case, and the numbers, there are more than one, for example, picture number 35. Number two, as the court noted and Mr. Rokar noted, in some of these pictures, you can't see the number. And most important of all, Your Honor, as the court noted itself yesterday, the best proof, the real proof, as to what pictures were taken in what order are the numbers on the Kodak print. That's the real proof. That's the hardcore proof.
Frame number on the film.
Frame number on the negatives. Now, the problem I have, and I mentioned it to Mr. Hodgman yesterday, is that Mr. Hodgman is the lawyer, and then later Mr. Yokelson, who was designated to be dealing with discovery for the defense. And this court is aware, and Mr. Hodgman has conceded candidly with this court, that they had no photo logs, they had no ordering of pictures, that they did not believe until we discovered this contact sheet from Bodziak that these contact sheets could be made from the negatives, that there was no ordering. I am very, very troubled by the fact that Ms. Clark is telling this court yesterday that she had a list of photographs and an ordering. Well, if she had it, and she had determined through conversations with photographers or detectives on this case, that she knew which pictures were taken in which order, then we are being misled because we are only dealing with Mr. Hodgman and Mr. Yokelson, who know of no information in the district attorney's office or in law enforcement that contain an ordering of the photographs.
Mr. Scheck.
And again, this goes back to the Bagley case. We were asking for a photo log or any ordering of the sequence of pictures. We were told there was none. We were told there's no ordering of the pictures. And we were seeking the contact sheets, which once again, Your Honor, is the best evidence, the only true evidence of what the sequence of pictures are because of the Kodak number, as the court noted itself. And we were continually told that this couldn't be done, this was not available, and we had to sit on the record as it stood. And this is very troubling because we were impeded, all our experts were impeded, we made repeated requests for it, from figuring out the order of pictures. Now, as the court, I'm sure, is aware that when Detective Lang and other detectives were on the stand, there were questions of them on cross-examination. They were even shown Mr. Rokar's earlier statements about his recollections of pictures being taken and when they were taken. We could not, until we got the contact prints finally, which only came about because Agent Bodziak requested that the negatives for some of these to be made, and when we saw that that was possible, we then requested that it be done, and the court so ordered it. When we got this late in the game, we were then able to interview Mr. Rokar, establish that these pictures were taken at night, and come up with very significant exculpatory information. This is a discovery violation, particularly if it's true that Ms. Clark knew the orders of these pictures. I would note that she also mentioned in passing, well, that's really the point. We were misled on this point and we're entitled to an instruction, as outlined in the sanctions motion, that we were deprived of this material and an opportunity to get the contact sheets and the best proof of what pictures were taken in what order until this date. And we think that is an inference that we're entitled to because this was I think that the requested sanction that we outline in that letter is strictly factual. There is another detail that's outlined there. And Mr. Hodgman and Mr. Yokelson were going to try to get it, but I asked him as early as the first day last week. I think it was Wednesday or Thursday of last week. I can't recall which, when we first saw the Bodziak contact sheet. We asked how long the prosecution had been in possession of that. And they were unable to get the date because that had come to Mr. Goldberg. Do we have the date on that? No? Do we know? Well, now I'm told it's within a week or two of Dr. Lee's testimony, but our point is that...
Before or after?
Before. At least before. But there should be some transmittal records that give a date. I left in the sanction motion, that date is blank. But the point is that we've been asking for this all along, and once they got a contact sheet, they can't, that's not impeachment. material, that's something we've been requesting from the beginning because it had obvious and crucial evidentiary significance. Rokar's testimony is highly exculpatory. We should have had that in our possession so we could have confronted all the witnesses at the time they testified at this trial and cross-examined them about it and pursued exactly where all these detectives were, at what time, between the Bundy and Rockingham locations. Because the state of the record now, I think, is devastating to Detective Furman's credibility and calls into question all the other officers' testimony. In addition, we think we have a right, and we have requested this in our Brady motion, and it relates to these contact sheets, to the investigation by the Los Angeles Police Department that Chief Williams has talked about, where they said they interviewed everybody and they determined that Detective Furman couldn't have possibly transported a glove from Bundy to Rockingham because they'd interviewed everybody. And they pursued all leads and conducted a complete investigation. Well, how can you conduct such an investigation without reviewing the contact sheets and the photographers and determining when these pictures were taken and the order in which they were taken? And we would like to see that report, which purports to say that Detective Furman couldn't have had access to that glove. Because we think now, in light of the Rokar testimony, it calls all of that into question.
People?
And thank you very much, Your Honor. Your Honor, I think the critical issue here is, did the defense have what the people have had, and did they have it at roughly about the same time? Mr. Schecht's chronology of the contact sheets is a little bit incomplete. We've talked about this informally, but let me advise the court of the more complete state of affairs with regard to the contact sheets. It is indeed true that early on in the discovery process, the defense inquired about a contact sheet. We didn't have a contact sheet. The prosecution did not have a contact sheet. We so advised the defense. We did, however, in order to ensure that the defense had all photographs, make our photo volumes, if you will, available to the defense, and those photo volumes did have some sort of rough order, and that was based on something that we observed in the photos and that the defense had in their photos. That is, down in the lower right-hand corner, there's sort of a little number imprinted in orange.
It's called a data back imprint.
Okay, I didn't know that. But which was in our photos, from which we derived some sense of order, and which the defense had as well. In addition, we displayed all the photos to the defense early on, probably a year ago at this point, to the defense with our little photo albums, if you will, of the photos in order. But we did not have contact sheets. In fact, the truth of the matter is the people did not have their own contact sheets until after the defense did. And that portion of the story goes like this. The defense requested an opportunity to view some photographs that had been utilized in connection with Dr. Lee's testimony. And Mr. Yolkeson and I procured those photographs, which were in a big box that had been sent out by Mr. Bodziak to Mr. Goldberg somewhere within a week, possibly two, in advance of Dr. Lee's testimony, in order to prepare for Lee's testimony. And primarily, there were photographs which had been enlarged. There were a couple that were magnetized. And contained within that box was a large proof sheet which appeared to have a number of negative strips in some sort of order. Now, we find out from Mr. Bodziak that these were strips that were selected by him and placed on that sheet, and that these are not a true contact sheet. These were simply a series of photos that Mr. Bodziak found of aid to him. And,
right. And what is Defense Exhibit 1366?
I don't know.
I'm sorry, say it again.
What is 1366? Is this an enlarged contact sheet, or is this which actually a proof sheet? Let's ask the photographers. What do we call something that is I think it's a proof sheet if it's in order, same size as a negative.
Okay.
That would be an enlarged contact sheet. The contact sheet would be the size of the negative, which is 1 by 1.5.
expert testimony for free.
Very, very good. Okay. Now we know that it's a contact sheet. What the court has, I believe, is something that was created last Friday with the aid of the prosecution, wherein we worked out an arrangement with the defense where an investigator of ours would go with all the negatives to the lab of their choice.
Excuse me, Mr. Hodgman, I just wanted to make sure this 1366 then is not the Bodziak contact sheet. It's something that was prepared and produced
Yes.
last week. Okay.
Okay. And with regard to that, that was created last Friday, and we infer from that process as that the defense hasn't given us the products of that effort, that they created their own actual contact sheets with photos in order. The people did not have that. Over the weekend, I directed the LAPD photo lab to prepare an actual contact sheet so that we did have something with all the photos in order as best as we can determine. That was prepared on Tuesday. I had a set made for the defense, and we have turned that over by way of discovery. So, truth be known, the defense actually had their own contact sheet with photos in order before the people did.
But Mr. Hodgman, shouldn't I be troubled by the fact that this request for either a photo log or a contact sheet was made ages ago?
Well, it was a discovery request, and at the time, if the court will recall, it was in the midst of many, many, many discovery requests.
But crime scene photos are pretty fundamental stuff, aren't they?
Well, had the defense come to us and simply asked, can we work this out, I think the people would have seen the value in that, would have appreciated getting them too. It never arose to that level until we opened Mr. Bodziak's box. And then very promptly thereafter, we obtained the contact sheets for the defense. The contact sheets never existed. They were never prepared until Tuesday of this week, at least on the prosecution side.
Since the request was specifically for a contact sheet previously that we've discussed, I mean, wasn't it incumbent upon the prosecution to at least see if that was available?
It's had they made a request and they could have come before this court, we could have had a direction to do that. The problem is it did not exist. It wasn't made. A contact sheet was not prepared until just this last week.
But contact sheets are something that are routinely made by photographers, especially photographers who take hundreds of frames. They don't want to print each one just to look at it to see which one they want to enlarge. I mean, it's done to conserve materials. It's done to conserve time. It's something any professional photo lab, which I assume the LAPD lab would qualify as a professional photo lab, would be able to produce with no
Your
problem
Honor,
whatsoever.
With regard to that, Your Honor, the people are under no obligation to create evidence. We did not have a contact sheet. We did not have a contact sheet until actually after the defense had a contact sheet. If the order of photographs were of such paramount importance and it had risen to that level, they know me, we could have done something about that. It never arose to that level until just recently. And with regard to that, again, it was...
How recently?
The first time it arose to this level of attention was when Mr. Scheck, Mr. Blazier, Mr. Neufeld, and Mr. Jokelson and I went through a box of Mr. Bodziak photos approximately a week ago Thursday. Because it was Friday, almost immediately we arranged for you guys to make the negative sheet. Isn't that right?
Mr. Hyde.
Yes, Your Honor. And just to supplement our argument, we have the defense photo books, and I think the court should take a look for them itself, at the photos with that little number, which the court correctly identified in the lower right-hand corner. So they had some idea of the semblance of order.
So you're saying no harm, no foul?
I'm saying we do not have an obligation to create evidence. And I'm saying when it did arise to a level of such interest for the defense, we reacted. We facilitated them going to a private lab, obtaining their own proof sheets. We showed what Mr. Bodjak had sent out. And then in addition, because as of Tuesday, the people did not have their own contact sheet. When we came into possession of a contact sheet, we provided it to the defense. The contact sheet did not exist until Friday of last week, when the defense created their own in a manner that we facilitated before we even had our own contact sheet. When we got the evidence, we gave it to the defense.
All right. Thank you, counsel. Briefly.
Your Honor, there are at least 2 photographers who took photos on June 13th. And when you look at these sets of photos, there are numbers that are the same. In other words, there'll be a 14 or a 35 in those little numbers across the face of the photo that are the same from 2 different photographers. And some of these numbers don't show up at all. So Mr. Hodgman is saying that, well, there's a rough order, but we found this extremely confusing and a number of times asked. I'm sure he forgot that, and in fact, in previous representations about this issue to the court, acknowledged that several months ago, Mr. Neufeld specifically came to Mr. Hodgman and again renewed this request for the contact sheets and an ordering of the pictures. And I think, as Mr. Hodgman will concede, he said at that time, and it has been the people's position, that they did not have any and could not make any available. Now, that's what we think is the problem. When he indicated that they did not have any available, we asked for access to the negatives, and he indicated that that couldn't be done. Now, what did happen last week after we saw the Bodjak sheet, and we realized that it could be done, or at least they would agree to have it done, is that we went over to the lab, and Mr. Neufeld was there with the representative of the district attorney's office, and so they were there when the sheet before you was created.
1366.
1366. Our point is this. There may be a left hand not knowing what the right hand is doing problem in the district attorney's office. It may well be that Ms. Clark knew the order of all these photographs from her precise investigation and looking at the numbers, but we certainly never did, and we complained about it long and loud, and a number of times to those assistants that were in charge of discovery. And we were told, it's not available, can't be made available, there are no negatives available to make this, can't be done. And as Mr. Hodgman just said, they took the position that they did not have an obligation to create new evidence or new contact sheets, and they had no photo log or ordering. Now, what this did for the entire case is put us at a severe disadvantage because we couldn't figure out sequence in a hard, definite way. And the only way that you could do, as a lawyer, what we did with Mr. Rokar this week was get those Kodak numbers, take those sheets, lead him through it step by step in order to firmly, irrefutably document that that picture was taken at night. You can't do it any other way. And we were trying to do it. And we were entitled to this. It was easily available. And I don't think they can stand on the ceremony of saying, well, we couldn't make it, we didn't make it, it wasn't available to us, we have no obligation to produce it. We say they had an obligation to produce it, and they liked it just fine, that we couldn't firmly establish the sequence of pictures, and that the crime scene photos, as the court noted, it's a basic. Dr. Lee testified, Mr. Regal testified, our experts kept on telling us they'd never heard of a crime lab that didn't have a photo log that at least gave you the orders, if not the times, that pictures were taken. And we have been seeking that from the very beginning of this case, and we have been frustrated, and the jury's entitled to know that. They had an obligation to turn this over. We were being misled about it, and we were not, despite specific and repeated requests for contact sheets and negatives which could have been made available, or a photo log that gave us an order of pictures. The people didn't turn it over. When it finally became clear that this could be made because Bobziak did something like that, and we were able to secure the negatives for purposes of a contact sheet, we came up with highly exculpatory evidence that we should have been allowed to confront officers with earlier, and the jury's entitled to know that they didn't do it.
All right. Thank you, counsel. All right, I'll take this matter under submission. All right. I'm sorry?
Your Honor, with the court's permission, the record is a mite incomplete, and I would like to take just a moment to make it complete so that the court has all the information upon which it can base its decision.
Briefly, 2
Yes.
minutes.
I'll be less than that. First of all, with regard to whatever Ms. Clark did with the photos, she made her own rough order based upon the little orange numbers in the lower right-hand corner. She was under the same deficits and disadvantages as the defense. She simply was trying to put them in some sort of order so that they made some sort of organizational sense for the people. I'm sure the defense attempted to do the same. I understand that they did when Mr. Cochran interviewed Mr. Rokar, I believe in this very courtroom, and appeared to have photo books based upon some sort of logical order. Secondly, at least as of last August, we offered to the defense an opportunity for them to come over and examine our photo books. Mr. McKenna came over to our offices, met with Mr. Fairlow, and the defense photos were in such a condition that very little effort was made to put them in some sort of order based on our books at that time. We extended an invitation to Mr. McKenna to come back and finish up based upon what we had in our photo books, and that invitation was never accepted. Mr. McKenna never came back. Thirdly, the recollection of Mr. Scheck and apparently Mr. Neufeld and myself differ in this degree. I've been consistent in saying there has been no contact sheet in the possession of the people, and that's true. That is absolutely true. With regard to it, could it be made, that is where our recollections differ. I would have to assume there is some way that this could be done, but again, the defense didn't appear to get very agitated about this until just very recently. That's all I have to say, Your Honor.
All right. Thank you, counsel. Yes.
Your Honor, one last point. Excuse me.
Changing the paper.
Where our recollections differ as well, I do not personally recall any request to make a contact sheet. I would have to assume that in the event that requests were made, I would have looked into it because that's what I do every time I get a request from the defense. So our recollections differ in that respect as well.
All right. Thank you, counsel.
All right. Motion, just very briefly. As you recall, we had filed, this is related to Brady, we had filed a request for the questions propounded by the court to prosecutors regarding the Detective Furman prep session, and I think that's still outstanding.
Okay. All right, let's take that up at a later moment. Mr. Cochran,
Yes, sir. Good morning, Your Honor.
who's next?
Our final witness, Your Honor, is Detective Mark Furman. We're ready to proceed.
All right, how do you propose to proceed?
Well, we'd like to call Detective Furman to the stand, Your Honor, and ask him, get his lawyer down here and ask him a series of questions, or as many questions as the court thinks is appropriate, and then move ahead.
All right, you've just filed your memorandum of points and authorities this morning
Yes, we did.
regarding this. I have not had the opportunity to read it yet.
I understand that, Your Honor. Now, you've been busy, so I wanted to indicate we're at that point, other than the other lingering motions.
All right, are both sides ready to argue this motion?
I believe we are.
All right, I'll hear
You
argument.
Clerk, you want to read our motion first, sir?
Well, this issue occurred to me a long time ago,
Okay.
so I've thought about it.
All right. I'm going to ask Dean Ullman to argue your motion.
All right, Mr. Ullman?
Once again, Your Honor is confronted with a unique, unprecedented situation.
Well, that only happens about twice a
We
week.
have filed a request for remedies this morning that suggested 3 remedies for the invocation of the Fifth Amendment by Detective Furman. First, to allow us to call Detective Furman in the presence of the jury, or alternatively, at least permit the testimony presented yesterday invoking the privilege to be read to the jury. Secondly, a special jury instruction advising the jury of his unavailability for further cross-examination. And finally, the admission of portions of the tapes and transcripts regarding prior acts of planting or manufacturing evidence to now be admitted as declarations against interest. The memo filed by the people, of course, takes a rather different view of how we should proceed from this point, suggesting that we simply do nothing, that we do not inform the jury of what happened yesterday and just proceed with the jury in a vacuum in terms of what became of Detective Furman. It's interesting that every case cited by the people in their memorandum involves essentially the same situation, and that is a witness who is called, cold, and invokes the Fifth Amendment. Not one of these cases involves a witness who invokes the Fifth Amendment after testifying on direct and cross-examination and after the jury has heard that testimony. Now, the apparent reason for the invocation of the Fifth Amendment privilege here is this witness's concern for prosecution for perjury for the testimony he presented to this jury. And we don't challenge that invocation of the Fifth Amendment. I think under these circumstances that is a realistic concern of the witness, and the case law seems to confirm that where a witness faces jeopardy of perjury prosecution for testimony previously presented in the case, that the invocation of the Fifth Amendment is privilege or is appropriate. But the situation before Your Honor then is very unique and very different from the situation posed in any of the cases cited by the prosecution. Your Honor is presented with a conflict between the defendant's right to present a defense and the witness's right to invoke a privilege. While that is a unique situation, Your Honor, it is not unprecedented. And we have found 2 cases in California that address the appropriate alternatives that the court should consider when it is confronted with this situation. The Reynolds case and the case of People versus Hecker. And we believe the Hecker case is most in point. Hecker involves a situation where a defendant is charged with a molestation. He brings forth a witness who will offer testimony that 3 days before the accusation of the molestation, the defendant's wife called him and sought to arrange a romantic relationship, and he informed her that that might be possible once her husband was out of the way. And then 3 days later, she accuses her husband of molesting her child. When this witness was presented, however, information came forth that the witness had some baggage. The witness had apparently made an offer to the wife to pay her if she would drop the charges against her husband. That, of course, involved potential criminal liability of this witness, and the witness indicated that with respect to that incident of offering to pay the wife, he would invoke the Fifth Amendment privilege. But of course, the invocation of that privilege would then render his exculpatory testimony unavailable. And the court in the Hecker case said the appropriate way to proceed under these circumstances is to permit the invocation of the privilege in the presence of the jury, so that the jury knows the area in which the defendant is, or the witness is invoking the privilege, and can simply balance that then against the testimony, the exculpatory testimony that the witness presented. And it's interesting that both the Hecker case and the Reynolds case cited by Hecker cite and rely upon the decision of United States versus Hearst, a case with which one of our co-counsel was intimately familiar, a case in which the defendant herself, in the presence of the jury, invoked the Fifth Amendment privilege 42 times. If I believed in the lottery, I think the number 42 might have some significance. It keeps coming up here. But in the Hearst case, the court ultimately determined that the invocation of the privilege was inappropriate, that the privilege was waived by Ms. Hearst getting up and testifying in her defense, so she really didn't have a Fifth Amendment privilege. But it's interesting that both Reynolds and Hecker deal with situations where the court concludes the claim of the Fifth Amendment was legitimate, that the witness had a Fifth Amendment right to refuse to testify, and the court in those cases suggested, well, the appropriate way under these circumstances to balance the defendant's right to present a defense against the witness's right to claim the privilege is to let it happen in front of the jury and then let the jury sort it out, because under these circumstances the claim of the privilege is relevant to an assessment of the witness's credibility. And in both of these cases, it was not appropriate to simply strike the testimony of the witness, and of course that is not an appropriate alternative in this case. That would deprive the defendant of essential evidence presented in furtherance of his defense.
So you're specifically not seeking the...
We are not seeking that the testimony be stricken.
Right.
But we believe it is appropriate that the jury know that Detective Furman is invoking the Fifth Amendment with respect to further cross-examination, and they should hear that cross-examination and that invocation of the privilege in their presence. We also have submitted, Your Honor, a proposed jury instruction which is tailored and modeled on the instruction approved by the Supreme Court of California in the case of People versus Hill. That proposed instruction simply tells the jury that out of your presence, Detective Mark Furman, this is an alternative, of course, was recalled for further cross-examination, that Detective Furman, with the advice of his counsel, refused to testify, basing his refusal upon his constitutional privilege against self-incrimination. Thus, Detective Furman is unavailable for further cross-examination. His unavailability for further cross-examination is a factor you may consider in assessing his credibility. This is, with the exception of the last two sentences, word for word identical to the instruction given in Hill. We believe the last two sentences are appropriate because, unlike in the Hill case, the jury has heard the testimony of this witness. They have heard a great deal about this witness, and they are going to wonder, what happened to him? Where did he go? Why was he not recalled by the defense? And this instruction simply informs them that he is unavailable and tells them why he is unavailable. It does not invite speculation about the invocation of the privilege. It just tells them that the invocation of the privilege has made him unavailable, and that his unavailability is a fact that they can consider in assessing his credibility.
But then shouldn't I include, if I accept this proposal, shouldn't I then include a sentence saying you are not to speculate as to the reason for the invocation?
We do not believe that would be appropriate in a circumstance where the reason for the invocation of the privilege relates to the possibility of perjury in the prior testimony. So we don't believe that instructing them that they should not speculate with respect to the invocation of the privilege would be appropriate under these circumstances where the defendant's right of confrontation and right to present a defense is impacted by the invocation of the privilege. But we have not proposed any instruction one way or the other about the impact of the invocation of the privilege. All that we're proposing is that the jury be told he's not available and his unavailability is relevant with respect to his credibility. Your Honor, the third remedy that we seek invites the court to revisit, and I know this is not an invitation that the court will welcome, but we believe that the invocation of the Fifth Amendment privilege, since it has made Detective Furman unavailable for cross-examination about the prior incidents of planting or destroying evidence, which Your Honor had indicated was not foreclosed by the prior order of the court, since he is now unavailable for that cross-examination, that those prior statements now qualify as declarations against interest, as an exception to the hearsay rule, and we have proffered 5 very limited excerpts that deal specifically with ripping up driver's license, scratching scabs, giving testimony as needed, whether he saw the events or not, that those particular excerpts from the McKinney tape do now qualify as declarations against interest. In fact, they really present us with almost textbook examples of declarations against interest. Your Honor will recall that California Evidence Code Section 1230 provides that evidence of a statement by a declarant having sufficient knowledge of the subject is not made inadmissible by the hearsay rule if the declarant is unavailable as a witness, which clearly the invocation of the privilege makes Detective Furman unavailable in this case, and the statement, when made, was so far contrary to the declarant's pecuniary or proprietary interest, or so far subjected him to the risk of civil or criminal liability, or so far tended to render invalid a claim by him against another, or created such a risk of making him an object of hatred, ridicule, or social disgrace in the community. I can't imagine any statements that could have more subjected a person to the kind of hatred, ridicule, and social disgrace in the community that Detective Furman now faces than the kind of statements he made in those taped conversations with Ms. McKinney. And the community that we're talking about, of course, is Los Angeles, not Sandpoint, Idaho. In this community...
Well, counsel, let's not cast aspersions on the state of Idaho gratuitously.
I don't intend to, Your Honor. What I'm saying is that under this exception to the evidence code, the social disgrace that the witness at the time he makes the statements may be subjecting him to is the social disgrace in the community of Los Angeles. And that's where these statements were made, and that's the degree of social disgrace that we're looking at. And this exception to the hearsay rule really adds a new dimension to the probative weight that Your Honor must balance under 352. So we believe it's appropriate to once again consider the offer of these declarations against interest. And in fact, the Hecker case also mentions as an alternative where a witness has taken the Fifth Amendment that prior statements then become declarations against interest and can be offered in evidence in addition to the witness appearing before the jury and invoking the Fifth Amendment in the presence of the jury. So once again, the court may look at these as alternatives, but we believe we would be entitled to do both, to call Detective Furman, and if he takes the Fifth Amendment in the presence of the jury, to then offer these prior declarations against interest, since we are foreclosed from confronting him with these statements and cross-examining him about them. And the statements go directly to the precise issue before the jury. They go directly to the incidents in the tape where there is discussion of destroying evidence or manufacturing evidence. So we believe, first of all, certainly our first choice would be to recall Detective Furman in the presence of the jury, alternatively to at least instruct the jury of his unavailability because of the invocation of the Fifth Amendment, and that can be considered as bearing on his credibility, and finally to permit now the admission of these 5 very limited excerpts from the McKinney tapes and transcripts.
Thank you, Dean. Ms. Clark. Good morning.
Your Honor, with respect to the, good morning. With respect to the motion to have the witness take the Fifth, invoke the Fifth in front of the jury, what's good for the goose is good for the gander, Your Honor. If the people can also have the jury informed that the defendant has invoked his right, then that's fine. And I'd ask that the court add the prophylactic to that as well, that the jury's not to speculate why he invoked his Fifth Amendment right. You know, I mean, it's the same improper thing. Now, let me cite the court to Section 913 of the Evidence Code. I don't know if the court's had the opportunity yet to read the people's brief in this, has it?
I have not read either brief, but I have contemplated the issue because the issue became apparent
That it was coming.
weeks ago.
Right. As did I, which is when I did the research and then asked a motion be prepared on it.
And it appears obvious that I'm going to have the lunch hour to read these things.
Right. You won't have to decide it now. So let me cite the court to that. And when the court reads that and reads our brief, I think that it will be very clear, because the case law is actually very clear, thankfully, on this issue. It's very clear from the Evidence Code that there's to be no comment on or any inferences drawn from the exercise of a privilege, and that for a jury to be informed of the invocation of a privilege is highly inappropriate and not to be countenanced. The case law that is on point in this regard is clear. And in our motion, we cite the court to People v. Ford, a case that I think our office is uniquely familiar with. In that case, though, it was indicated from Ford and its progeny repeatedly that the witness should take the Fifth outside the presence of the jury, and the jury should not be instructed that the witness has done so. And there are a number of cases in that. Since the court is going to read the brief, I'm not going to go over each and every case in that regard. Let me simply point out, though, I think it's more germane and productive of the court's time that I distinguish the cases cited by the defense. The cases cited by the defense, beginning with U.S. versus Hurst. In U.S. versus Hurst, we have a completely different situation. In that situation, Ms. Hurst elected to take the witness stand and speak, testify. And in essence, what the court found was, you have waived your privilege. You really have none. And so if you decide you will not answer certain questions of the prosecution, the privilege having been waived, it can then be remarked upon to the jury, because everything is fair game. You have lost the cloak of invulnerability that the privilege gives you, and once that waiver has been given, everything that you say is fair game, including your desire to invoke as to certain questions, because there is no such thing as a limited right to invoke in which you invoke in some questions and not in others. Once you waive, you waive. And that's exactly what's so unfair about what the defense deliberately did to Mark Furman yesterday. I don't stand in his defense, but you've got somebody on the ropes. He has taken every hit that they can think of to give him. I'm not saying they're inappropriate, but to then get up and ask him another question. They know he cannot afford to answer any questions, or there will be a waiver deemed. And as to maybe some of the past acts of misconduct, and they may be something as simple as calling someone in a rude manner, not even using an epithet, but saying, "Hey, you son of a gun," or "Hey, you son of a bitch," or something like that. Officers get time off for that. Officers get reprimanded for that. What you do not know is why he was going to invoke, and that's why it's improper to speculate. That's why any kind of instruction that a witness has taken the fifth should never be given, because no matter how many times you tell them don't speculate, that's precisely what the jury is going to do. And that's precisely what Mr. Cochran is asking the world to do with respect to the improper question they posed to Detective Furman yesterday, whether or not he planted evidence, knowing full well that he did not plant evidence, knowing full well that he could never say he didn't plant evidence, because the minute he answered that question, there's a waiver. It's unfair. This highlights exactly why that's unfair. Anyway, in U.S. versus Hurst, in any case, there was a waiver. And so then she invoked. It was proper under those circumstances, with her invoking on the witness stand, to comment on that. It goes to her credibility. It goes to her demeanor. Because there is a waiver, so she no longer has the protection of the Fifth Amendment. With respect to the Hecker case.
Excuse me, counsel, would you approach the sidebar without the court reporter, please? Ms. Clark.
Thank you, Your Honor. The Hecker case is also easily distinguished. In that case, first of all, the witness intended to invoke at the time of his initial testimony. That's a significant difference, because number one is, when you know in advance that a witness is going to invoke before they take the witness stand at all in the case, in that situation, it's improper to have the witness invoke in front of the jury. What you do is you let the witness invoke, and then he's taken out of the presence. The jury is not informed. In that particular case, though, it was dicta, because what happened was, in that case, the witness intended to invoke at the time of the initial testimony, and the court, I believe, the court was concerned that he would have to strike all of the witness's testimony if the witness invoked as to any of the parts he was intending to invoke. And so what the court did, I believe, was find that there was another way it could have been handled. It found that it was appropriate not to allow the witness to testify under the circumstances at all, but it said this, that if the party calling the witness knew the witness intended to invoke as to certain subject matters, but not as to others, and the party was willing to take the liability of a witness who would invoke as to certain things and not as to others in return for getting some of the testimony, that party who was willing to accept the liability could do so. Of course, the jury could then see the witness invoking, but the party has gone into the situation with eyes open. It was an observation made in dicta in the case. It in no way indicated that it approved of the practice of having a witness invoke outside the presence of in the presence of the jury, or have the jury informed somehow of the witness's invocation where the party calling the witness did not intend to take that liability on as a conscious thing. Thank you. As Ms. Lewis points out, that was also an appellate court case that was decided before 1990, before the Supreme Court cases that indicate in no uncertain terms and in very clear language that this should not be done in the presence of the jury, and the jury should not be informed of the witness's invocation. People v. Hill, also cited by the defense, did not urge or approve that the jury be informed of a witness's invocation. It simply found that informing the jury in that case of the witness's invocation was harmless error under those facts, because the jury was in fact told by the judge why the witness was not available. In that situation, the defense had gotten in the witness's statement, which was self-incriminating, which explained, it was an incriminatory statement, I can't remember what it was. They got that in the absence of the witness, and I believe it was under 1230 in that case. The judge, in order to prevent the jury from speculating as to why it came in without the witness testifying on the witness stand, told them that the witness had invoked. What the court found that to be was harmless error. Error nonetheless, harmless because it was clear that the statement was self-incriminating, and so the fact that the judge ultimately did tell the jury that that's why the witness wasn't there kind of didn't matter. But it certainly did not urge or approve the practice urged upon this court by the defense in any way, shape, or form. With respect to the 1230 argument proposed by the defense is now seeking to backdoor the court's ruling to get in what the court has already deemed to be inadmissible. The same observations apply now as they did then. Unless these statements are true, they are not probative. They are not relevant. And unless we engage in the mini-trial of whether or not they are true and how to determine whether or not they are true, they should not be deemed admissible because they're not probative of anything. Also consider that under 1230 of the Evidence Code, Your Honor, these statements have to have been made in a manner that the witness would think to be damaging to him in either a pecuniary, social, or proprietary risk of civil or criminal liability. Excuse me. Now, first of all, pecuniary, it's certainly not. He intended to make money on this, but more important than that is that these statements were made in confidence, as Laura McKinney herself stated. There was not an intent for him to publish the tapes, obviously. The intent was for the information that was imparted to her to be made part of a fictional work. And now we come into the trustworthiness aspect of every Evidence Code section. Excuse me, counsel. And under this section, the trustworthiness has got to be deemed absolutely nil. We have Mr. Furman making remarks to a screenwriter for the purpose of creating a fictional work. No matter how hard the defense wants to claim that this is based on reality, this is based in fact, Ms. McKinney testified before this court that there was no effort made to fact-check anything that he said, because it didn't matter. It didn't matter whether it was true or not. All it mattered to her was to get his statements, his stories, whether they were true or not. It was information she could use to make a work of fiction. It was not a documentary. And she made that very clear as well. As a matter of fact, the statement she made in North Carolina was, we intended to make up a story. So we have no trustworthiness with respect to any of the events here. The court has already properly ruled that these statements are inadmissible for all of the reasons cited in the brief. I think it's inappropriate and not productive of our time to go back into all of the arguments the court's very well familiar with. They cannot be proven true. If not true, not relevant. They are certainly not probative. They were made under circumstances that make them highly suspect as to their trustworthiness or veracity. They were made in confidence, and so they don't satisfy any of the requirements of Evidence Code Section 1230. In conclusion, then, Your Honor, I think that once the Court has had an opportunity to read our briefs, and I'm sure the Court is familiar with the case law is clear, thankfully, in this matter, that the defense has no right to have the jury informed of Detective Furman's invocation of the Fifth Amendment in any way. That would be inappropriate. It would be inappropriate because it causes them to speculate as to why. In the alternative, if the Court deems it appropriate to so advise the jury, I do urge the Court to advise the jury also that Mr. Simpson has invoked his right against self-incrimination. And if the Court deems that appropriate, then tell them not to speculate about either one, because the improper speculation would occur.
We'll just toss Griffin out.
Well, that's fine. Throw away Griffin. They're asking you to throw away case law as well, Your Honor. They're asking you to throw away the case law that's cited in the People's Brief, Supreme Court cases, People v. Ford, People v. Mincy. If you're going to throw those out, throw out Griffin. You know, I'm not saying that the Court should do that. I'm saying that they're equally inappropriate. It is slightly different as to a witness, because a witness may take the stand and then all of a sudden invoke and require that there be some kind of measures taken to inform the jury they should not speculate. But when it is known that a witness will invoke, it is not to be done in front of the jury. For all of the same reasons, it would be inappropriate to do it for the defendant, because people will speculate no matter how much you tell them not to. With respect to Evidence Code Section 1230, that simply has not been satisfied in any way.
All right. Thank you, counsel. All right, Mr. Ullman, I'll hear your response at 1:30. No, I said I'll hear your response at 1:30. What part about 1:30 don't you understand? Okay.
Excuse me, Your Honor.
Yes, Mr. Haddon.
Before we adjourn for the morning session, I would ask that in the event that a Pitchess motion is filed for my client's personnel file, that I be served with that as well. I don't think the statute requires that, but in light of the Court's seeming predisposition to entertain an order shortening time, I would like as much opportunity to be able to respond to it immediately. So I would ask that...
All right, I'm certain counsel will do that as a matter of professional courtesy.
Thank you.
And I'll direct them to do so.
Thank you, Your Honor. And one other thing is, I'd like to ask if my client is excused for today.
Yes, sir.
Yes. Thank you. All right, we'll be in recess.
Please clear the courtroom.
All right, back on the record in the Simpson matter. Mr. Simpson is again present. All parties are again present. Jury is not present. Mr. Ullman.
Thank you, Your Honor. In listening to Ms. Park's argument, I had to wonder whether we were talking about the same Fifth Amendment. The Fifth Amendment that I understand offers a witness a privilege against self-incrimination of a crime. The suggestion that the Fifth Amendment could have been invoked by Detective Furman for fear of being reprimanded for using naughty words is preposterous. That's not what the Fifth Amendment protects against. Moreover, he's not even a detective anymore. What we're talking about is incrimination of a crime, and the crime that entitles this witness to invoke the privilege at this point in the proceedings is the crime of perjury. And Detective Furman's fear of a perjury prosecution is a very realistic one, especially in view of the veiled threats that have been emanating from the prosecution. We heard reference to the potential case of People versus Furman and how we would settle a number of issues when that comes about. There is a realistic concern by this witness of a prosecution for perjury based on the testimony he presented earlier in these proceedings. And that, make no mistake about it, is the only legitimate ground he has to invoke a Fifth Amendment privilege at this point in the proceedings. And I believe that is a highly relevant fact in terms of how Your Honor assesses the impact of the invocation of the Fifth Amendment at this point in the proceedings. The reference to sauce for the goose being sauce for the gander also represents a misunderstanding.
Don't even bother to address it.
All right. Well, we'll submit an appropriate instruction, but I think there is an important distinction to bear in mind here, and that is the risk to a witness of whatever inferences might be drawn from the invocation of the privilege versus the risk to a defendant, because the risk to a defendant is the risk that a jury will use this as evidence of guilt. But the risk to a witness is minimal, and Your Honor need not really be concerned in terms of the witness himself, what impact an adverse inference might have. We only want to look at that inference in the context of its relevance to these proceedings. And we believe that the fact that the invocation of the privilege makes this witness unavailable to us for further cross-examination is highly relevant to these proceedings and highly relevant to the jury's assessment of his credibility. Now, the case law, there's been reference to the California case law being of one mind on this issue, but what's ignored in the prosecution's argument is that all of the cases they cite deal with the same situation of a witness who has not testified, a witness whom the jury has not seen, whom the jury has not heard, and the impact of having that witness invoke the Fifth Amendment in the presence of the jury. The case that we are primarily relying on, the Hecker case, addresses this concern directly in the context of balancing the defendant's right to present a defense versus the witness's right to invoke the privilege. And they indicate that because, for example, striking the testimony would deprive the defendant of the fundamental right to present a defense, it should only be utilized after less severe means are considered.
And I haven't heard either side request that I strike his testimony.
Well, what we're talking about here are the less severe means, but the less severe means of balancing that right to a defense versus the right of the witness to the privilege. And Hecker suggests that the appropriate balance in that particular case would have been to let the jury hear the invocation of the privilege and factor that into their consideration of the credibility of the remaining testimony. And Hecker is a 1990 case, cognizant of all of the Supreme Court case law, cognizant of the privilege contained in our evidence code, but they're saying under these circumstances, we've got to balance the defendant's right to present a defense. The case of People versus Hill did not hold, as Ms. Clark suggested, that it was harmless error to give an instruction to a jury that a witness had invoked the Fifth Amendment. What the Hill case held was that it was not error to deny the defense request in that case to have the invocation take place in the presence of the jury. And the court noted in coming to that conclusion that the jury had been informed by means of an instruction identical to the instruction that we are requesting here. And it's important to remember that Hill, too, did not deal with the context of a witness that the jury has already heard from. And that's really the problem we've got to deal with here, that the jury has heard from Detective Furman, they've seen direct examination, cross-examination, they've seen him on the witness stand for 6 days, they've heard him talked about, they've heard a drove of witnesses come in to impeach him, and they know that when he stepped off of that witness stand, it was subject to recall. And they're bound to wonder what became of Detective Furman? Why didn't the defense call Detective Furman back? And what we're seeking to avoid is an inference unfavorable to the defense because of the unavailability of this witness for further cross-examination. So we want the jury to know he's not available to be cross-examined, and the reason he's not available is because he invoked the Fifth Amendment privilege, and you can consider his unavailability in assessing his credibility. Now, with respect to the alternative remedy that we have sought, the prosecution has suggested that the 5 excerpts that we have offered may not be true. They may be exaggerations by Detective Furman. But the prerequisite for admission under Section 1230, under the exception to the hearsay rule, is that the circumstances suggest reliability, that ordinarily a person would not make statements that would subject him to criticism in the community or potential criminal liability unless they were true. And we have singled out specific instances from the McKinney tapes in which it's very clear that Detective Furman is talking about things that he did. We're talking about, did you tear up driver's license? And he nods that he did. We're talking about a response to a question under where I'm the 3rd or 4th car. And then I go in and provide the testimony that's necessary to get a conviction. In terms of his concerns when he made these statements, bear in mind, this is the Detective Furman who says to Miss McKinney when she asks, well, can we use this in the screenplay? No. Hasn't been 7 years yet. Statute of limitations. If that doesn't show a consciousness by the speaker of potential criminal liability, I don't know what does. But alternatively, regardless of whether there's a potential fear of criminal prosecution or simply a fear of social ostracism, the result is the same under Section 1230. These are declarations against interest. They are highly probative declarations against interest, and we believe that the unavailability of Detective Furman should render those statements admissible.
Thank you, Counsel. All right, the record in this case indicates in our hearing yesterday outside the presence of the jury, and that was an appropriate procedure to proceed outside the presence of the jury because the counsel for Mr. Furman, Darrell Munger, did advise the court that it was and counsel that it was a possibility, in fact, a likelihood that Mr. Furman would, in fact, seek to exercise his right not to testify under the Fifth Amendment to the United States Constitution. After we held our hearing yesterday afternoon, the record is also clear that Mr. Furman will refuse to answer any further questions as a witness in this case, and he is therefore unavailable within the definition of Evidence Code Section 240. The record is equally clear that when we adjourned, that the cross-examination as to Detective Furman was adjourned subject to recall for further cross-examination. The subject matter that Mr. Furman is likely and reasonably and appropriately subject to further cross-examination, we have heard over the last day and a half 4 witnesses who have come in to testify for the specific reason to impeach the testimony of Detective Furman. Kathleen Bell was called, and this is not a particularly compelling reason for further cross-examination since Detective Furman was in fact asked questions about Ms. Bell on direct examination and cross-examination, and there was sufficient opportunity since counsel on both sides were aware of the facts and circumstances that led to Ms. Bell coming to the attention of counsel on both sides. However, as to Ms. Singer, as to Mr. Hodge and as to Ms. McKinney, Detective Furman was not direct or cross-examined as to any of the statements made by those three witnesses who were called for the specific purpose of impeaching Detective Furman. The prejudice to the defendant, based upon this unique set of circumstances, is the inability to further cross-examine as to these three witnesses and the impeachment evidence that they have offered through their testimony, that is Singer, Hodge, and McKinney. However, the case law is equally clear to the court that it is not appropriate to call a witness before a jury that counsel know will invoke the privilege, and that is clearly the fact and circumstance here. And the court will therefore deny the request to recall Detective Furman at this time in front of the jury. The instruction offered as an alternative by the defense, which has been already read into the record and which is page 3 of the defendant's points and authorities, does have the disability of mentioning the invocation of the right against self-incrimination. Evidence Code section 913 clearly states that it is not appropriate to comment upon or bring to the finder of fact's attention the invocation of a privilege. California Jury Instruction 2.25, CalJIC 2.25, deals with the situation where a witness, in the course of testifying before the jury, invokes the privilege, and then the jury is then instructed not to infer or imply anything from that invocation. Therefore, the court will instruct the jury as follows. Detective Mark Furman is not available for further testimony as a witness in this case. His unavailability for further testimony both on cross-examination is a factor which you may consider in evaluating his credibility as a witness. Now, having found that Detective Furman is unavailable as a witness under Evidence Code section 240, the court then has re-examined its ruling with regards to the 5 excerpts which are now offered as statements against penal interest. And the court, having evaluated those, finds that the court's previous ruling was appropriate and the objections will be sustained. All right. You ready to proceed?
Then we have a moment to discuss.
I'd like to address the court. We feel that the proposed instruction that the court is going to give to this jury will cause the jury to speculate on the reason for his unavailability.
Counsel, I've ruled. That's a final ruling. Thank you. Scheduling.
Maybe we have just a couple minutes to talk about a couple things we may be doing. I think the court knows who we are on this point, so I'll just take it.
All right. I'm likely to instruct the prosecution to be ready to start with their rebuttal witnesses tomorrow morning. And we'll take up the issue of admissibility of the exhibits probably later today.
We will move for reconsideration tomorrow morning.
Well, I'm going to instruct them. I'm going to instruct them this afternoon.
And let me say just a quick
All right.
we'll be ready. We'll let you give
All right.
let Ms. Robertson know in just a second.
10 minutes.
Oh, thank you very much. 2 o'clock, we'll be ready.
All right, back on the record in the Simpson matter. All parties are again present. Ms. Clark.
Yes, Your Honor. We are preparing an emergency stay at this time. I request from the court a written ruling indicating the basis for its ruling concerning the jury instruction proposed.
All right, that
and
request is denied.
case authority that supports the giving of the instruction that the court has proposed.
All right. I'll have the clerk and the court reporter prepare a transcript of the proceedings and the arguments today. That'll be your record.
Okay, and the case authority that the court has relied upon for this, for the instruction? Emergency stay at this time. We would request until tomorrow morning before the court consider instructing the jury on this matter. We do need the time to prepare the paperwork in order to submit it to the Court of Appeals. If I may remind the court has previously given the defense time to submit appeals.
I don't know that I've given them time, but I've encouraged them to do so.
In any event, the court has previously given the defense time to prepare their appellate papers in order to file them, and I'm asking leave of the court to give the people the same opportunity.
Till 9 o'clock tomorrow morning?
I will consult with appellate. I think that at least that long would be required. I would also urge the court to consider the fact that an immediate instruction to the jury is not necessary. The jury will be given a number of instructions at the end of this case, and that will be ample time to give that one if it is deemed appropriate by the court at that time. So it's not like this is something that needs to be done at this very moment.
All right. Mr. Cochran?
We'd like, the court has already ruled. You've indicated you've ruled. The jury's here. They've been sitting on their hands since 10 o'clock this morning. We want to proceed on. We want to get to a point where we can effectively rest. Ms. Clark misstates what the court said to me last Thursday was, Mr. Cochran, you know where the Court of Appeals is right down the street, if you want to do that. And
Right down the street, a block and a half.
a block and a half. Well, you have total recall. You invited me that, and you didn't give us any time to do anything. You just told me where the Court of Appeals was.
You didn't ask for any.
And I didn't know. I didn't ask, but she said you gave us time. You didn't give us any time. We didn't ask for that. Your Honor, we have to bring to conclusion. They knew this day was coming. Everybody knew that. It's not going to save them till tomorrow morning. What you're doing is minimally, entirely appropriate. We want to move on with this case, Judge. We have a jury that's going to be mutinying very shortly, as this court knows, and we need to resolve this matter. We saw them walk through here. They're distressed. They should be able to hear something, find out, as we talked about this morning, this case will be over within the next 7 or 8 days, given rebuttal and rebuttal on both sides. And I think that's at least some good news for these folks, and they have a right to that. And we want to resolve this matter. No reason to wait until 9 o'clock tomorrow morning. It's not going to change anything. If they want to bring a writ, they can bring a writ, but it's not going to stop anything. You are not abusing your discretion in this regard. And we want to proceed. You've ruled. You told them you'd ruled, and let's go on with it.
All right. Thank you, counsel. Ms. Clark, Mr. Cochran, as Dean Allman mentioned, this is a unique factual and legal situation, something I've never seen before, never had to contemplate before. Of course, that's nothing unusual in this particular case. I'll give the prosecution till noon tomorrow. Let's stay on that. And we will have final instructions, my guess is in the next 10 days to 2 weeks. But giving a stay might cause me to modify the instruction to say that at the close of the presentation of the defense case, Detective Mark Furman was not available, etc., so that the point in time is set in the instruction. All right. Mr. Cochran, anything else?
Well, you guys put us in a position. We can't rest until, I guess, till noon tomorrow, so that effectively what they've done is wasted the rest of the day and half a day tomorrow. We can't really do anything, can we, based upon this? And nothing's going to come of this, Your Honor. This is a matter of your discretion. We argued the law, and I can understand Your Honor being patient, but I just think that you ought to reconsider this, because we do have, at the whim of this one prosecutor here, we have these 14 jurors back there. So what if we lose all of them by virtue of this is going to be a wasted action? And tomorrow at noon, you'll do the same. We'll do what you're going to do right now. We will have lost all that time. Right before the break, Your Honor indicated, be prepared for rebuttal tomorrow. It means we'd cut off one more day, or at least a half day. So that's all I'm saying, is I'd urge the court to reconsider that. We're going to be in exactly the same position, Judge, it seems to me.
Well, Mr. Cochran, really, at this point, given the unique situation, factual and legal situation presented by the Furman situation, I doubt that a court of appeal, frankly, is going to intervene on an interim jury instruction. I would be surprised if they did.
I would too, Your Honor.
And especially in light of the nature of the instruction. Given that fact, I think it would help us all if you rested at this point, subject to asking to reopen if an issue is presented by the change by the Court of Appeal of the jury instruction. But I don't know what other witnesses you would call, even if the instruction changed significantly or was withdrawn.
Well, if I can have a moment, I might consider that. I might consider doing that,
The
Your Honor.
reason I say that is we've got the jury. If they knew that you were resting today and that the prosecution could move forward with their rebuttal case tomorrow morning with the witnesses that they have planned, and that we will spend the remainder of today going over the evidence that the defense is going to offer and resolving those disputes. Tomorrow at 2 o'clock, we have motions on calendar for public agency access to the Furman tapes. We can conclude, hopefully, the evidence issues after we conclude that hearing. And we can move along with unhesitatingly into the conclusion of the rebuttal case next week.
The only problem with that, Your Honor, and certainly we want to cooperate with the court, but we're doing all the giving. We're doing the resting. We're on track to resolve this. And they're standing over there being petulant, saying we want to wait till tomorrow. And so I'm saying that I want to be reasonable. I'd like a moment to confer with my colleagues. But I mean, I think that...
Well, I'm just suggesting to you that even if the Court of Appeal were to intervene, would you call any additional witnesses in light of that, given the court's other rulings, et cetera?
I don't know, Your Honor. Perhaps we might, if they insist on this, we might join on the writ and ask the court to allow us to play the rest of those tapes. You know, be careful what you ask for. You've said that many times. Right?
And I'll say it again.
Be careful what you ask for, right? May I have a couple minutes, Your Honor?
Certainly.
Now, may I ask that the court has been very clear that it does not appreciate personal attacks. Mr. Cochran stands before this court daily and engages in that very thing at sidebar and before the court, saying that the jury is being made to sit at my whim. It's not a whim when the people feel that there's been a violation of law that may seriously impact on the people's right to a fair trial. That's no whim. That's serious. And I am the advocate for the people. It is my duty to make sure that when I think a violation of law has occurred to the detriment of the people, or the defendant for that matter, it is my duty to do all that I can to make sure that that is remedied.
Thank you.
That's no whim, Your Honor.
Thank you.
And I'm not being petulant in insisting on enforcing those rights. Nor did I ever accuse the defense of being petulant when they asked for time to prepare a writ to reinstate a juror, which the court generously gave them, and to which we did not object.
Thank you.
I have what I hope is a reasonable proposal, Your Honor. We'd like to do everything that you've asked with regard to, there's a stipulation on Matheson, there's the argument regarding the evidence, and any of those things you want to do. We want to do everything with the exception of resting until such time as this matter is resolved, because we think the natural and logical thing is to give that jury instruction at that point. So everything else we can do, and we'd ask leave the court to do it that way.
It's very coherent, doesn't satisfy my needs today.
As we do everything you ask, Your Honor, except we will rest, you know, at that time, if it's noon tomorrow or 11:59 or so, and then ask you to read the instruction at that point. I think we don't lose anything by that, Your Honor. And you've already told the jurors that we're at that point. But I think that just from the standpoint of discussing with my colleagues and my client, we just don't feel that it would be appropriate for us to rest at this point, Your Honor. But we'll do everything else. Be available as late as you want or as early as you want tomorrow. One reason why and I'm sure you appreciate this, the next logical thing, as you've said so many times, it's a smart jury. The next logical thing, based upon the evidence we presented over the last 2 days, is that, and they know Mark Furman was never excused because in their presence you said that he was on 72 hours call, is it doesn't take a rocket scientist to know that would be the next logical witness. And so we think it inures to Mr. Simpson's detriment to talk about resting at this point, and we want to rest at the point when the instruction is read. I think that explains it, it makes sense, and that's why we made that decision, Your Honor. But other than that, we're ready to proceed with everything you want, as late as you want to stay today, and tomorrow, and all the other issues, so we don't really lose anything.
Problem is, then we can't start with then why don't we reschedule the argument on access to the tapes at 9 o'clock, and we'll start the rebuttal case tomorrow at 2 o'clock. And go to 5.
No, we're fine. We're fine with that.
All right.
No, we're not.
Why?
The court represented to us at sidebar this morning that we would not begin rebuttal until Monday. I went up and instructed everyone to have the witnesses stand by for Monday. And I don't know that we can get someone in now at this short notice.
Have them here have them here tomorrow at 2 o'clock. 2 o'clock.
I cannot represent that we can, based on the court's earlier representations to us.
Well, then you'll rest. Have them here at 2 o'clock.
Is the court now going to penalize the people because the people are exercising their appellate rights as they're entitled to do? It would appear that you are.
I'll see counsel in chambers. Back on the record in the Simpson matter. All parties are present. Jury is not present. Deputy McNair, let's have the jurors, please. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Well, at least 2 of you are smiling. 3. All right, ladies and gentlemen, good news, bad news. The good news is that the defense has told me that they do not anticipate presenting any further witnesses. And if you recollect, when we concluded the prosecution's case, I had to take about a day to go through the evidence, all of the exhibits that had been presented to me. And as you know, there have been several hundred exhibits that have been offered by the defense so far, and I have to go over each one of those pieces of evidence to determine whether or not they should be submitted to you for your deliberations when the time is appropriate. So the good news is that we will be concluding, I anticipate, the defense case by tomorrow. Is that correct, with no further witnesses, Mr. Cochran?
Well, I would anticipate that's perhaps correct, Your Honor.
All right. I've also instructed the prosecution to be prepared to present their first rebuttal witness Monday morning. And Ms. Clark, you anticipate being able to present your rebuttal starting on Monday morning, correct?
Yes, indeed.
All right. My understanding is that the rebuttal case is presently estimated to be 5 days by the prosecution, and then perhaps 2 days of sur-rebuttal by the defense. Is that an accurate assessment, Mr. Cochran?
I believe so, as regarding the server.
All right, Ms. Clark.
We're not related yet?
Yeah.
I think that's good.
All right. So the good news is that the end is in sight. The bad news is I got a lot of work that I have to do out of your presence, and I apologize for keeping you on hold today. Some significant, and I have to tell you, issues came up that I had never had to deal with before. I had to do a lot of research on the issue, and one of the issues is not yet resolved. So I still have to work on it. I want you to know that we will be in session for the remainder of today, going over the items of evidence with the lawyers. Tomorrow morning, I anticipate we'll have to spend concluding that. And tomorrow afternoon, I have another hearing set at 2 o'clock as to a completely different issue that involves this case. So we're working hard. But I want you to know that the bailiffs do tell me that you're not happy campers again. And I appreciate that. And my biggest concerns when I discuss these matters with the lawyers are your feelings and the inconvenience to you. But that's the bad news, is that I don't have anything further to present to you today or tomorrow morning in all likelihood. We have activities planned for you tomorrow afternoon. There are also some doctors and dentist appointments that we need to take care of with you all, so we're not available to do anything tomorrow afternoon. So at this point, unless I hear from you further, I'm going to wish you a good weekend, but you should know that we'll be here working a full day tomorrow, Friday. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Allow anybody to communicate with you with regard to the case. And have a nice weekend. All right, thanks for the couple of smiles there. All right, as far as the jury is concerned, we'll stand in recess until, I'll put them on call for tomorrow morning, but we'll stand in recess, in all likelihood, till Monday morning, 9 o'clock. All right, we'll take a recess to clear the jury, and then I'll see counsel with regards to the evidence. Both sides have their lists? All right, let's take 10.